Welcome everybody to another exhilarating action-packed courtroom episode of Lockdown 23-1. That's right, I said I was going to take a little break from the courts, but I mean, it's been about a week and a half. And I gotta tap into this one while it's fresh. I don't know if you remember the individual that jumped over the bench and attacked the judge, but today he's going to be sentenced for it. And just to give you a little intel on the situation, back in January 3rd, he was going in front of a Clark County judge to be sentenced for attempted battery charge. It says here, in the moments before the attack, Redden told the court he was working and was in a better place of mind. He also says, I feel like I shouldn't be sent to prison, but if it's appropriate for you, then you gotta do what you gotta do, speaking to the judge. So it sounds like he's ready for whatever. But obviously he wasn't. The judge said he was going to get a prison sentence, and immediately he jumps over the bench and attacks her. It says the judge sentenced Redden up to 4 years in prison in connection with the baseball bat attack on a person last year. If I were to guess, he turned those 4 years into decades. Let's find out, but first, as always, if you're new to the channel and enjoy all things lockup and crime related, then this is where you want to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today. My oh me oh my. Look at a still frame of this beaut here. We'll be coming back for that courtroom analysis, don't y'all worry. Jeez, what are we on, a dining table? Already getting giggly. These mics are sounding on point. I can hear every jingle. Man, I remember like it was yesterday coming out those doors right there to face the judge. It's a nervous, anxious, bubbly gut feeling. Terrifying. We can still hear your whispers. Man, it's been a while since I've seen a Montel drop top. Gleaming. I could probably take a good nap listening to, random courtroom banter like this. Is it banter? Is that the word? Just small talk. For some reason, I feel as though that is not the word. Looks like we're going to have to do some fast forwarding here. Bobby, warm up the smoke, man. There we go. There we go.
All rise.
Oh, damn, he came in smiling? Oh, no. Toasteroni. The last thing you want to do is come in smiling like that when you're about to get sentenced for attacking a judge. Yeah, he must be trying to get that insanity plea.
Mr. Redden?
Yes, I.
Okay, I need you to stand, sir.
Okay. Sorry, I feel a little nauseous. The pain right here.
Are you okay?
Yeah. I'm feeling embarrassed like you.
Okay. All right, sir, I have your guilty plea.
I'd feel a little nauseous too.
Here in front of me, which, as you know, was filed in open court on September 5th of 2024. I canvassed you on this guilty plea memorandum. You signed it, and you answered all of my questions. I am adjudging you guilty, but mentally ill, to committing the following crimes. Count 1, attempt murder, victim 60 years of age or older, a Category B felony, in violation of NRS 200.010, NRS 200.030, NRS 193.153, and NRS 193.167. Count 2, battery on a protected person resulting in substantial bodily harm, victim over 60 years of age or older, a Category B felony in violation of NRS 200.481 And count 3, intimidating public officer, a category C felony in violation of NRS 199.300. Count 4, battery on an officer resulting in substantial bodily harm, a category B felony in violation of NRS 200.481. Count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property, resulting in substantial bodily harm or death, a category C felony in violation of NRS 202.595. Count 6, battery by prisoner, a category B felony in violation of NRS 200.481 subsection 2F. And count 7, unlawful act relating to human excrement or bodily fluid, a category B felony in violation of NRS 212.189. Does the state have anything to present?
Yes, Your Honor.
All right.
Thank you. Your Honor, before I begin my argument, I would note that he has 16 days credit for time served, and that is because he's been under sentence of imprisonment in the case that he was sentenced on in front of Judge Holthus when the events in this case took place. Additionally, the state is requesting a total of $61,318.41 in restitution.
Wow.
$61,318.41
in restitution, and it should be paid to CCMSI. That's the company that administers the workers' comp claims.
They smoked him even on the fines, man. 61 G's.
For the 3 officers involved in this incident that sustained injuries. As the court's aware, we filed a very lengthy and detailed sentencing memorandum.
I know, I read that too.
So I'm not going to spend a whole lot of time regurgitating everything in there, but there are some things that I want to point out for the court.
Regurgitate. Never heard that word in
In
forever.
our sentencing memorandum, we are asking for significant prison sentences as to each course of conduct, and we're requesting that as to each course of conduct, the sentences run consecutively to one another.
But did you have some
Back to back.
concurrent? I'm looking at page 3.
So the counts would run concurrently as to the victim, but consecutive between the various victims, essentially.
Right.
And so it's the state's position, Your Honor, that the defendant's very lengthy criminal history, his demonstrated lack of impulse control, and his inability to completely accept responsibility for his conduct, as well as the egregious actions in this case, warrant.
Homeboy's giving the Grinch stare down to her.
2011. In each event, as you read through the reports, they all stem from his poor impulse control issues. And prior to this case, he was convicted in 12 other cases. They all involved some level of violence. In 9 of the 12 cases that he committed new offenses while charges were pending.
Alright, so let's fast forward a little bit. The prosecution district attorney's just going to go into depth on his past criminal record, how they're all violent for the most part, and he ain't learned his lesson. Deserves a hearty prison sentence. If you want to watch the full episode and hear everything that she had to say, I'll leave the original video linked in the comment section below. But like I said, we're going to fast forward to the defendant speak his mind, and it gets long-winded as well. So go ahead, grab another Mountain Dew, spritzer, tea and scrumpets, whatever you desire, and prepare yourself for an emotional roller coaster.
Your Honor, I'll let Mr. Redden speak first. He wants to address the court.
Oh no, let's see.
Miss Judge Susan H. Johnson, I don't understand why the state is like really going after my character. I mean, I've always had problems since I was a little kid of like psychosis and being in big crowds and always feel like my life is in danger. I didn't know, being a young person, even in middle school, elementary school, knowing that like I fear for my safety. I'm just being me, going to school, growing up, trying to do the right things. I never get tired of trying to do the right things. The state just said that I have no remorse. Like, I feel like Judge Johnson, she doesn't know me. I understand she's doing her job. I'm not mad at her for that. But I know that I'm not a bad person. And I'm thinking, like, even she knows that, but I'm sitting here like she's doing her job, you know? And I believe that you all know that I'm not a bad person. I'm not an evil person. When I came to court on January 3rd, 2024, I was listening to music, I was in a good mood, I had a stable place to stay, I was trying to get a job, I did not catch any new charges, I'm not a bad person. I don't understand why the state is trying to prove me as a bad person. I understand they have a job to do, but this is just, it's not right to me, you know? I'm not an evil guy, and I just keep going after me. I see spirits, I hear voices. I've been going through this for over a decade now, really since 2012, you know? And I just feel attacked or just not safe since I was a little kid. And me growing up, I didn't know that I had these problems. In 2022, I came to prison for the first time. I accepted responsibility for my actions when I did what I did. I committed a crime in 2020 of December. It was 4 years ago. I paid my debt to society. I got out thinking I'm gonna get work. I was really sick and ill. I was very malnourished. I don't complain about things. I don't point the blame when people have done me wrong. I still treat everybody right. And the state just stated that I have no remorse and they feel like I'm a bad person. I just don't understand why are they coming after me like this. But I understand they have a job to do. When I came to court, I know for a fact, Judge Johnson, I met Judge Holthus in 2023 of October, and you know what she told me when she revoked my probation? She said, Mr. Redden, I hope you get the help you truly need. I said, thank you so much, and I meant it. I know for a fact I'm not an evil person. I think all of you guys know that, you know? But I'm not gonna use stuff like me being on camera for my actions, you know? But I know for a fact that I cared about Judge Mary Kay Holthus' well-being. When I left my house that day at 8 Road Circle, I left my keys to my apartment, to my family, you know? And I got in the car and I came to court doing the right thing. I gave up everything, like in case I don't get probation. I was like, well, at least I know I tried. And I'm sitting here talking to Judge Holthus, Ms. Johnson, and I swear I started hearing voices in 2012, really in 2014. I'm gonna make a long story short, but I just want to get the facts out because I don't want the state. I understand they have a job to do, but I'm not a bad person. I'm not an evil guy. But I came to court. And I'm in a good mood. I'm listening to music on my phone. I'm like, oh, whatever. I remember I about to hug my mom, my foster mother who raised me since I was 11 years old. I hugged her like, just in case if I don't get pressure. You can see it in the videotape yourself. I was in a good mood. I don't want to be known as a person who has mental illness because those people get attacked.
Man, he don't want people to think he's crazy. I'm here to tell you, I think that'd probably be the first thing I want people to think if I was in his shoes right about now. Right? From what I understand, you know, if you got a little bit of crazy in you, you might not do as much time. And you might go to like a nice little padded room or something. Anything's better than that dungy prison cell.
Commit things that they really don't mean. I hope I don't have mental illness. I try not to have mental illness, you know. I don't want to be known as a person who has mental illness because they get attacked, you know? So I try my best when I'm going through all these problems. Since I was a little boy, like I told you, I didn't know I had these problems until 2 years ago. I was sitting down in prison and I had this dictionary and I was like, oh, that's what that word means. That's what that really means. I didn't know that. Oh, stuff has a deeper meaning. You know, like, wow, I never think like this. I was in prison with nothing to do. I did a 12 to 30 months. I did 15 months total and I cleaned up my sentence. I paid my debt to society and I got out as a good, productive member of society. I didn't know and didn't want to believe that I had mental problems, you know. I started seeing spirits November 2022. I'm not making excuses for my actions, but I'm saying I'm not a bad person. And I know that I did not intend to kill Mary Kay Holthus. I know I cared about her well-being, Judge Johnson, you know? And I came to court that day and I was talking to her and I told her I never stopped trying to do the right things. I wasn't pointing like, oh, this person did this to me. I deserve a chance at probation. Like, this is not fair. All I see was red and all I heard her say, oh, this, like she said, and I finally watched the whole video. I was standing here in the courtroom with all of you guys, and I finally saw the entire video. Judge Johnson, I can't believe this. And I wasn't even mad at Michael Lasso. I was like, I commend him on doing for what he did, and everybody in the prison trying to make me hate him and hate the judge, and I'm still trying to do the right thing. They putting stuff in my ear and I can't get away from it. But basically what I'm trying to say is everything I've been doing, this is just like not right to me. But like I said, I know the state has a job to do. And basically what I'm saying is, I know I cared about Mary Kate Holthus, to make a long story short, but when I was sitting here talking to her.
Hell no, that
I
wasn't
swear
short.
this happened to me since
Still going.
2012. I saw nothing but red, and I heard her say, I think it's time for a taste of something else. I saw nothing but red, and I don't remember doing anything except for jumping on top of her and doing this to her robe. I was like, why are you doing this to me? That's what I wanted to ask her, if I think I know myself, but I'm not really sure. That's the only thing I could come up with. I had 11 months, but I can't really come up with anything, but I know that I cared about Judge Mary Kay Holthus's well-being, you know? That's all. Thank you.
Powerful. I believe you.
Can you sit during mine?
I believe you.
Sure.
Your Honor, again, I hear the state in that they're saying it's a lack of impulse control. I agree with that. However, he's adjudicated guilty, not guilty, but by mental illness. And so, bottom line, his ability
Oh, he was adjudicated guilty by mental illness. What does that exactly mean? We're gonna find out, I guess.
to control his impulses are vastly different from my ability, from, Mr. Giordani's ability. He does not have the same ability to control his anger, what he's going to do, because as you saw in Dr. Paglini's report, from day one, from birth, he has had this mental illness based upon his mother's drug use at the time of her pregnancy, the stuff that he saw during him growing up, going through different households, going to a stable home in his foster parent, but he was still unable to comply with just normal behaviors. And that all of that should be taken into account. I think this case starts again in April of 2013. The 18th is when he was arrested after going after his brother-in-law with the baseball bat. Basically, again, this was during a period of time where he wasn't doing his medication. He was off his meds. He's going through his paranoid disorders, whatever those that were outlined by Dr. Paglini. And this whole incident arises from that. He gets into court and he's deemed incompetent. He can't comply with the normal court proceedings that were occurring. He refused transport 3-4 different times. Then he gets into court and he's unable to control himself. Why? Because he wasn't on medication. He goes to competency court. He is eventually given medication to subdue the voices, to subdue his impulses, and he's able to comply. That person that is able to comply is the person that we see today, Your Honor. We made sure that he was on his medication. We asked the prison. I asked him personally. That wasn't done prior to his sentencing in the original case that occurred out of the 2023 incident. And that's the other point I wanted to bring up. This case is very different than most of the cases where we have a mentally incompetent person in the court proceedings. Usually, their incompetency keeps them in custody. This is the first that I'm aware of that they're actually released out of custody. He was released, and then he had the inability to get back on the medication that was being given to him free of charge at Clark County Detention Center. He tries to make appointments, as you saw in Ms. Springer's affidavit, to get this medication. For 2 months after his release, which again is an occurrence that I haven't seen before, he's unable to get that medication. Of course he's going to slip back into the same impulsive behaviors that he had before. Of course he's going to slip back and not being able to suppress the thoughts and delusions that he was having. He went back right to what we saw in August 2023. And so again, that should all be taken into consideration. The state is asking for consecutive time. In part and parcel, his mental illness continued from the 2023 incident all the way until today. He was never released after sentencing in January 2024. We're asking, and I'll get to how much time, but we're asking that it all be run concurrent with his sentence that was received from Judge Holtis, the 1948, to whatever Your Honor believes is appropriate today. And the reason why we're asking for this to be concurrent is simply because he didn't have the chance to get out. He didn't have the chance to rehabilitate himself. He didn't have the chance to demonstrate to the court that, okay, he learned his lesson. He was still under the state's control during the time of his sentencing.
This is a great attorney. He's not arguing how much time he's going to get. He already knows he's going to get a bunch of time. The biggest factor here, just like many cases we've done in the past with people that have multiple crimes, it's if they get sentenced to concurrent or consecutive. Consecutive means they have to do the time for each charge back to back. Concurrent means they're bundled all up into one package, and he can do the time for all of them at once.
The same state that we forgot to inquire prior to his sentencing whether he was under his medication, the same state that didn't provide him with his medication, the Mojave Health Clinic, being it during the holidays, was unable to give him an appointment. I believe that this case has shed light on people's mental illness and what we have to do to, number one, bring them into court and understand what they're going through. And I don't think the answer is just throw away the key, give them a whole bunch of years. That benefits no one. We understand that a message has to be given. Since he's been on his medication, as you see him today, Your Honor, he's being courteous, he's being compliant, and he's deeply remorseful about the events and what happened that day. What I haven't shared with anyone other than my staff, and me and Mr. Redden talked about it. The first time that he saw the entire video was right here in court during the presentation of evidence. I was sitting right next to him. His reaction was very visceral. It was almost like he wanted to throw up. He called himself a monster. He did, Your Honor. That's me. I'm a monster. I can't believe that I did that. I did not mean to hurt that woman like that. I can't believe that I did that. That's what he said sitting in the same exact chair during trial. I believe he just, like he said, he doesn't have any specific recollection of coming over the bench, but when he saw it, he was deeply remorseful. He was just shocked about how he could act that way. And I think, Your Honor, all that should be taken into consideration. He understands the difficult position that you're in. We talked about this at length. I told him, there's just no way you're going to be granted probation in this matter. That was spelled out to him. Also, what was spelled out, there has to be a message that, you know, you can't come flying over the bench because you didn't get the sentence that you wanted, or you're upset with the sentence. There has to be protection to your honor, has to be protection to the prosecutors, has to be protection to everyone in the courtroom. And so that message has to be sent so we don't have the next Joe Schmo that gets upset and takes it out on court staff or anybody surrounding them. He understands that. And with that understanding, he knows that he has to do some time. What we're asking for, Your Honor, is a 4 to 11 year sentence. How we got to that
ain't happening.
was a 2 to 5 on counts
Wow.
1, 2, 3, 4, and 5, all to run concurrent. Consecutive to that, and by statute, counts 6 and 7, we're asking for a 2 to 6. So the total of that and the count 6 and 7 are run concurrent with each other. So, and we're asking also that be concurrent with his current 19 to 48 sentence. So we're asking for a 4 to 11 year sentence. I think that's sufficient considering, number one, his mental illness that he was under, his inability throughout life to control his actions based upon that mental illness, the state and our failure to be able to recognize mental illness and what we should do in terms of addressing it, getting him the type of help, and not just throwing him into prison, but figuring out ways, which we're not equipped with, but a psychologist would be more adept to figure out how to help these individuals and give them a life plan or whatever it takes, so when they do get out into society, they're able to comply and have appropriate behavior. As you saw from Ms. Springer's affidavit, this was an individual, coming off of his meds that still wanted to comply. He had a living arrangement. He was trying to get to his appointments. He even obtained a job at the Teamsters union and received a dispatcher job, while he was waiting for sentencing that day. This is a person that can...
That's a teardrop, man.
Be able to do it.
That ain't no
even
crocodilian
with
either.
Appropriate help from a psychologist and mental health counselor.
That teardrop got a few voices with him.
Again, Your Honor, considering all the information that was provided to you, considering the gravity...
I think he knows that smoke's about to start
his
pouring.
mental illness and his life, that you...
Mr. Redden, I am not going to run any sentence that I impose today concurrent with that issued by Judge Holthus. In my view, you committed separate crimes, and that results in separate sentences. So it's not going to run concurrent to what she has previously issued as far as a sentence.
At least she didn't bait him around for a while. She got to the point. No concurrent sentencings today. The question next is, how much time is she going to give him?
With respect to this sentence, first of all, there will be a $25 administrative assessment fee, a $3 DNA administrative fee. And Mr. Arnold, were you appointed or were you retained on this?
No, I actually did this case pro bono, Your Honor.
Okay.
Ah,
There will not be any DNA testing fee because
pro bono, ladies and gentlemen. I don't know if you know what that means, but I had an attorney pro bono and he was a beast. Beat some major felonies I had, but they were bogus. Victims lying all over the place trying to get me smoked like a Chattanooga train set. But pro bono, correct me if I'm wrong, is a paid attorney that's doing free work for the state. Most states issue law firms to do this type of free work. I don't know if it's monthly, yearly, or what, but every once in a while, a defendant will get lucky and get a paid attorney for free, pro bono. Man, and that suit is crisp. He's got his head down, though. He already knows what time it is. They can't say he didn't try his best, though.
given your history, it's already been taken. Your actions on that day, you know, it was not just retaliation for an attack upon Judge Holthus, it was also an attack on the judiciary. And I'm mindful of that. And while there is no question that you've got some mental illness issues, which is why you pled guilty but mentally ill, but there was no doubt by these doctors that you knew the difference between right and wrong. So this is what I'm going to do with respect to the sentence.
Oh no, hand on his shoulder.
With respect to count one, sir, I'm going to do this. The minimum term that you would serve would be 8 years, and the maximum term will be 20 years. Plus, there will be a consecutive potential maximum term of 8 years to 20 years. So with respect to count one, the minimum term that you will be serving combined would be 16 years, and the maximum will be 40 years. With respect to count two, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. With respect to the consecutive enhancement, the age enhancement, the minimum that you will serve will be 4 years, and the maximum will be 10 years. So with respect to count two, the minimum term combined will be 8 years, and the maximum will be 20 years. The term that I impose with respect to count two will run concurrent to count one. With respect to count three,
I ain't gonna lie, I'm lost on the time already. I think he's got like 30 at the minimal.
the minimum term that you will serve will be 2 years. The maximum term will be 5 years. That term will run consecutive to count one. With respect to count four, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. That also will run consecutive to counts 3 and counts 1. With respect to counts, well, wait a minute, yeah, okay. With respects to counts 6 and 7.
We're all getting a little lost.
The minimum term in both of those counts will be 4 years. The maximum term will be 10 years. However, those will run concurrent to each other, right? So I'm not following what your attorney has suggested. I am following what the state has suggested. Did I catch them all?
I believe you skipped 5.
With 5?
Correct.
Oh man, we skipped a felony.
Okay. The sentence with respect to count 5 will be a minimum term of 2 years, and the maximum will be 5 years. That will run consecutive to count 4.
Ay, ay, ay.
And then counts 6 and 7 are concurrent to each other and concurrent to...
And consecutive to, well, wait a minute. That was, count 6 was with respect to Officer Brandon, right?
Officer Boo, you're on 6
Officer
and 7.
Boo. That will run consecutive to counts, the other counts. see if I can.
You know, when the courtroom gets a bit stagnant, I like to just jump into a quick courtroom analysis. We got ourselves a plethora of Radio Shack equipment, HDMI cords, wall mounts for the monitors, all the way down to the long neck projector, guaranteed to see your sentence from 3 blocks away. Once they dim down that beautiful Elon Musk false moon lighting, every courtroom tends to have those these days. But this is extraordinary. Never have I ever seen African black wood in the courtroom like this. Usually it's just used for a little bit of trim, but a full tabletop is unreal. For those of y'all that don't know, the African blackwood is native to the seasonal dry regions of Africa. The tree is an important timber species native to its areas. It's used to manufacture musical instruments, sculptures, or vinyaga in Swahili, and fine furnitures as you're seeing here in the courtroom today. Not only is it amazing because it's a rare type of wood and color to be used in the courtroom, but I've never seen anything match up perfectly to the rhino lining leather chairs. Wait a second, I'm just now recognizing this. Is that Captain Jean-Luc Picard's Enterprise seat? This judge is boldly going where nobody's gone before. And the command center is unlike any other. 1, 2, 3, 4 monitors. One of them has to have the defendant's heart rate on it. Every judge likes to see that thing elevate. I'm just playing, man. I'm just playing. You know, these courtroom analysis can get out of control sometimes.
To run consecutive to counts 1, 2, 3, 4, and 5.
Right.
And then as far as count 7, it's to run concurrent to count 6.
Correct.
Thank you.
Could you give me the aggregate, please? When you get a chance, and you need a aggregate?
Yes.
Everybody's tallying up.
You show 26 to 65.
Ooh, wow.
I'm going to verify. Well, that does sound about right, but let's verify.
And Your Honor, as to the restitution?
There will also be restitution to the victim.
Thank you, Judge.
I still keep coming up with 36 on the top. Maybe it's 26. So here on count 1.
Yeah, they're having an issue trying to accumulate the total number here.
That's 8. And 8 goes into...
Someone got 26, other person got 34 or something like that, so
Added 8 over 20.
we're gonna have to do some long division here.
Right.
And then here you have
Man, I haven't seen this before ever in my life in the courtroom.
Well, after this will run...
concurrent. Oh, it's
Concurrent.
concurrent. I'm
Concurrent.
sorry, that's why.
Okay.
Okay, so 26.
Yeah, count 2 will run concurrent to count 1.
So 26 on the bottom. How many months did you have on the bottom? 120?
We have 26 years to 65 years aggregate.
65. That looks about right.
Okay. And there will also be restitution to the victim, payable to the victim in the amount
I know,
of
man.
$61,318.41, and that is CCMSI.
Yes, Your Honor.
And what does that stand for?
I don't know. I apologize, Your Honor.
Okay. Could you do me a favor?
I can look
Let
it
me
up.
know what that is, because
Yes.
we need to put that in the judgment of conviction. And
Huh.
we need to give this gentleman credit for time served.
16 days.
60 days?
16 dusty days.
Okay.
Thank you.
Thank you, Judge.
Okay. Thank you.
Well, there you have it, ladies and gentlemen. Low end 26, high end 65 years in prison. What do you expect, man? Mental issues or not, you can't be attacking no judge. They're gonna paint you up and put you on display like a piece of artwork. Crazy to think if he never attacked that judge, he would have just gotten 4 years max. But stay tuned, I got a couple more crazy courtroom episodes coming your way. If you're new and enjoyed, tap that like, subscribe, notification bell before you leave. And as always, until the next time, y'all be easy, be safe, and more importantly than anything, stay free.